Hello friends, welcome to iExam's Law Channel Legal P. In this video today we are going to discuss important landmark judgments of Constitution. You will see a gist of the most important judgments related to the Constitution of India in this video. These judgments are very important first for the judiciary exams, especially for prelims where you have Constitution as a syllabus, and also for answer writing in mains. Also, this is important for Indian polity subject, which has its own separate paper in UPSC mains. There, these judgments will help you in writing a very good and comprehensive answer and gain some extra marks. And thirdly, if you are opting law optional in UPSC, then in paper 1 syllabus, the Constitution of India is present as a subject, and there these judgments are very important. This is in the form of PDF. I'll be discussing the gist of the judgments. You can download this PDF from the description below and you can read the gist for quick learning and the detailed explanation that is given below the summary table. Here, starting with the first judgment, A.K. Gopalan versus State of Madras. This judgment is related to Preventive Detention Act, and in this judgment, the Supreme Court held that the Preventive Detention Act does not violate Article 19 and 21 of the Constitution. A restrictive interpretation was given, and later this judgment was overruled in Menaka Gandhi case. The second judgment is Romesh Thapar versus State of Madras. Here the court noted that the expansive restrictions under Madras Maintenance of Public Order Act 1949 were unconstitutional and that only narrow restrictions on freedom of expressions were permitted. The first judgment was related to Article 19 and 21. Second was with respect to the freedom of expression, that is Article 19. Then the third important judgment is Shankari Prasad versus Union of India 1951. In this judgment, the power to amend the Constitution under Article 368 also includes the power to amend the fundamental rights. So here the court held a stand that fundamental rights can also be amended under Article 368. Then the next judgment was K.M. Nanavati versus State of Maharashtra. The government here abolished jury trials as a result of this case. A very famous movie is also there on this case law. Via this judgment, the jury trials were abolished. The next important case is Berubari Union Case 1960. Here it was stated preamble is not a part of the Constitution. Then in Sajjan Singh versus State of Punjab 1965, the Shankari Prasad judgment was reiterated and it was stated that Parliament has the power to amend the fundamental rights. Then in I.C. Golaknath versus State of Punjab 1967, it was stated that Article 368 provides procedure for constitutional amendments and amendment to the Constitution is law as per Article 13 of the Indian Constitution. Fundamental rights cannot be amended. So there was statements related to Article 13 and amendment was also considered a law. Fundamental rights, however, cannot be amended. Then there was landmark judgment of Keshwananda Bharati versus State of Kerala 1973, where the doctrine of basic structure was introduced. Basic structure of the Constitution must not be abrogated, even though a constitutional amendment is made. Also, it was stated that preamble is a part of Constitution and it can be amended. Then in Indira Nehru Gandhi versus Raj Narayan case 1975, the basic structure doctrine was reused. Using the theory of basic structure, Supreme Court struck down Clause 4 of Article 329A, which was inserted by 39th Amendment, which placed the election of President, Vice President, Prime Minister and Speaker of Lok Sabha beyond the scrutiny of Judiciary. Then in ADM Jabalpur versus Shiv Kant Shukla case 1975, it was also called habeas corpus case. Here the court held that fundamental rights can be suspended during emergency. Then the next one is Husainara Khatun versus Home Secretary, State of Bihar. This case propounded rights of under trial prisoners, right to speedy trial under Article 21 of the Indian Constitution. This case also threw light on the importance of free legal aid. So this case was related to the rights of prisoners, their right to speedy trial, their right to free legal aid. Then Minerva Mills case 1980. This again strengthened the basic structure doctrine. The judges ruled that a limited amending power itself is a basic feature of the Constitution. The case is also very important in determining the harmony and balance in between DPSP, Directive Principles of State Policy, and fundamental rights. Then there was Vaman Rao case 1981. The Vaman Rao case held that the amendments made to the ninth schedule until the Keshwananda judgment are valid, and those passed after that date can be subject to scrutiny. Ninth schedule was made and various laws were placed in the ninth schedule with the idea that whatever is kept in the ninth schedule, that is beyond judicial scrutiny. In Vaman Rao case, the court held that until the Keshwananda judgment, that is until 1973, whatever laws have been placed in ninth schedule, they are valid, they will be beyond judicial scrutiny. However, those passed after that date can be subject to scrutiny. The next important case is SP Gupta versus President of India case. The major issue in this case was appointment of judges of High Court and Supreme Court. The issue of locus standi was also settled in this case for public interest litigations. Then let's move to the 15th one, that is Bachchan Singh versus State of Punjab 1982. It was a death penalty case. The court expounded the principle of rarest of rare case in Bachchan Singh case. The court said life imprisonment is the rule and death penalty or capital punishment is the exception. It should be rarely given. In rarest of rare cases, capital punishment can be awarded to the convict of murder. The next important case related to Constitution is Indian Express Newspaper Private Limited versus Union of India. The court reasoned that a government can levy taxes on the publication of newspaper. However, this must be within reasonable limits so as to not encroach upon the freedom of expression. Then there was Kehar Singh and others versus Union of India, which is also called Indira Gandhi case. The president is entitled to go into the merits of the case regardless of the fact that it has been judicially concluded by the consideration given to it by this court. There is no right for the sentenced person to insist on an oral hearing before the president. This is with respect to the pardoning parts of the president. So when a person goes to the president to request for pardon, the president can go into the merits of the case. Then the next important case is Sheila Barse versus Union of India 1988. Here the court held that the petitioner is free to make an application for interview of prisoners to prescribe authority, and when such application is made, it shall be dealt with accordingly by the jail authorities and subject to public order, decency and morality. So here in this case, the petitioner was asking to interview the prisoners and the court held that the petitioner is free to make an application to the prescribed authority and it shall be dealt with by the jail authorities subject to public order, decency and morality. Then Indira Sahni and others versus Union of India, which is also called Mandal Commission case. Here 50% cap was imposed on caste-based reservations. The Apex Code also upheld separate reservations for OBC in central government jobs but with the exclusion of the creamy layer. Then another important case is Mohini Jain versus State of Karnataka 1992. The Supreme Court of India held that the charging of capitation fee by the private education institutions violated the right to education as implied from the right to life and human dignity and the right to equal protection of the law. So here it was stated that capitation fee is against the right to education. In Unni Krishnan JP and others versus State of Andhra Pradesh and others 1993, the Supreme Court held that the right to basic education is implied by the fundamental right to life in Article 21 when read in conjunction with the directive principle on education. There is no fundamental right to education for a professional degree that flows from Article 21. So right to basic education is there, but right to professional degree is not enumerated in Article 21. Then in SR Bommai versus Union of India 1994, the President exercised the power under Article 356 to issue proclamation, and it was said that the exercise of such power is subject to judicial review, at least to the extent of examining whether the conditions precedent to the issuance of proclamation have been satisfied or not. 356 is with respect to the President rule. Then the next case is Union Government versus LIC of India. Here it was stated that preamble is an integral part of the Constitution. In the next case of Vishakha versus State of Rajasthan, Vishaka Guidelines for Protection of Women Against Sexual Harassment at Workplace was made. Later, the legislature has carved out the Sexual Harassment at Workplace Act 2013. The next case is Bandhua Mukti Morcha versus Union of India and others. The Supreme Court of India in this public interest litigation case directed the state of Uttar Pradesh to eliminate the carpet industry's use of child labor and issue welfare directives prohibiting child labor under the age of 14 and provide children access to education and health facilities in an effort to abolish child labor. The next case is L. Chandra Kumar versus Union of India, and it was with respect to the tribunals. Tribunals established under Article 323A and 323B have the authority to investigate the legality of subordinate legislation, but they are not permitted to investigate the legality of their parent law. Then moving to 27th case law, T.M. Pai Foundation versus State of Karnataka. Here only the state can determine the status of a religious or linguistic minority. Judgment 28, Supreme Court's Advocates on Record Association versus Union of India. This is also called Fourth Judge's Case. In this case, constitutional validity of 99th Constitutional Amendment and National Judicial Appointment Commission Act was challenged. Supreme Court in its verdict held it unconstitutional as it violated the basic structure of the Indian Constitution, that is independence of judiciary. Judgment 29, Lily Thomas versus Union of India. Here, mere conversion of religion would not result in the marriage dissolution solemnized in accordance with the Hindu law unless a decree for divorce is being obtained. This is related to the conversion of religion, and it is also related to the Hindu Marriage Act, the Hindu laws. Then Judgment 30, I.R. Coelho versus State of Tamil Nadu 2007. The 9 schedule items are not immune to judicial review as it is part of the constitution. दैट मीन्स वामन राव केस में जो पहले डिस्कस हुआ था वो आई.आर. कोएलो केस में रीट्रेट हुआ है दैट द 9 शेड्यूल आइटम्स आर नॉट इम्यून टू जुडिशियल रिव्यू. Judgment 31, Gyan Singh versus State of Punjab. The judgment in this case fortifies the principle that if the offence is primarily civil in nature and a settlement is arrived between the parties, the High Courts can compound such offences while exercising its inherent power under Section 482 of the Criminal Procedure Code. So in Gyan Singh versus State of Punjab, the power of compounding by the High Courts was discussed. Then Judgment 32, Nas Foundation versus Government of NCT of Delhi, Suresh Kumar Kaushal and another versus Nas Foundation and others 2013. The Delhi High Court ruled that Section 377 cannot be used to punish sex between two consenting adults. Section 377 is unnatural offences. This violates the right to privacy and personal liberty under Article 21 of the Constitution. The Supreme Court of India set aside this 2009 judgment. Section 377 IPC does not suffer from the vice of unconstitutionality. Judgment number 33, Shreya Singhal versus Union of India. This judgment is with respect to section number 66A of Information Technology Act, which was held invalid, being violative of Article 19(1)A, right to freedom of expression. Then the next is Justice K.S. Puttaswamy. Versus Union of India. Here, right to privacy was held a fundamental right as per Part 3 of the Constitution of India. In Indian Young Lawyer Association and others versus State of Kerala and others, the restriction of women in Sabrimala temple was held unconstitutional, and after this judgment, women were now allowed in Sabrimala temple. Judgment of P. Rathinam versus Union of India held that the right to life under Article 21 also includes the right not to live, and there is no justification to prosecute those who attempt suicide. So here, after this judgment, attempt to suicide was no longer a criminal offence. Next judgment is Gyan Kaur versus State of Punjab. Here, section number 306 and 309 of IPC were made constitutionally valid and were held as not being violative of Article 21 and 14. The bench held that the right to life as under Article 21 did not include the right to die and the right to be killed. So by this judgment by Gyan Kaur versus State of Punjab, the attempt to suicide was again made a criminal offence. The next important judgment is Aruna Ramchandra Shaunbag versus Union of India. Here, The court allowed non-voluntary passive euthanasia since the victim was not in a state to give consent for the same. So by this judgment, passive euthanasia was made legal. Then the next judgment is Common Cause versus Union of India 2018. Here the court reaffirmed that the right to die with dignity was a fundamental right as declared by the Constitutional Bench of the Supreme Court in the case of Gyan Kaur. Then last judgment of this video, People's Union for Civil Liberties versus Union of India. Here it was held that right to live with personal liberty includes right to food and livelihood. So this was a gist of all the 40 important judgments related to Constitution. Below this gist you will find the detailed version of what these cases were about and what was held in these cases. Some contain the entire specific of the case and some contain only that is relevant to the exam. So you can download this entire PDF. You can read out all the important judgments, all the important points relating to the judgments, and also you can remember using the gist that is provided in the beginning. I also want to tell you about the judiciary course. We are soon coming forward with the judiciary batch where there will be weekly classes, there will be comprehensive discussions of certain topics already mentioned, and then at the end of the week there will be objective tests based on that discussion, based on that topic, and one means test also containing descriptive questions. Subscribe to our Legal Bee YouTube channel. This is your one-stop solution for all legal exams. Stay tuned with such relevant videos. If you want judgments for any specific subject, you can mention them in the comment box. If you have any queries or you want any form of guidance, you can reach out to us on this number. You can also write to us on this email ID. Subscribe to our channel, click the bell icon. iExamBee helps you prepare 50% faster with a crisp and concise content, and you can already see that from this judgment document. Subscribe to our channel, stay tuned. Thank you.